Welcome, everybody. Good evening, dear colleagues and dear friends, ladies and gentlemen. Welcome to the second Chinese American Scholar Forum. My name is Yiguan Zhu. I'm a professor in the Department of Mechanical and Aerospace Engineering at Princeton University. I'm the past chair of the US sections of the Combustion Institute. Tonight, we are hosting this forum representing that US Chinese American researchers in the Combustion Institute. The topic of tonight's forum is the Department of Justice China Initiative. Does it make America stronger or weaker? Tonight, we are very pleased to have two distinguished panelists. The first one is Mr. Jay Bratt from the Department of Justice. Jay, welcome and thank you for joining us. Jay, thank you. And Jay Bratt is the chief of the Counterintelligence and Export Control section of the National Security Division in the Department of Justice. The Export Control section is responsible for overseeing all prosecutions involving that Espionage Act, economic espionage, export control, sanction violations, cyber intrusions, and malign foreign influence. Before becoming the chief, Mr. Bratt served as the deputy chief of the National Security Section in the United States Attorney's Office for the District of Columbia. Mr. Bratt is a graduate of Harvard Law School at Brandeis University. Thank you, Jay. Our second panelist today is Professor Margaret Lewis from Seton Hall University, the School of Law. Maggie, welcome and thank you for joining us tonight. And Professor Lewis' research focus is on law and China and Taiwan. She's an expert of criminal justice and human rights. Professor Lewis has been a Fulbright senior scholar at the National Taiwan University, a visiting professor at Academia Sinica, and a public intellectuals program fellow with the National Committee on United States-China Relations. She's a member of the Council on Foreign Relations. Before joining Seton Hall University, Professor Lewis served as a senior research fellow at the New York University School of Law, working on criminal justice reforms in China. She's a graduate of NYU and Columbia University. I would like to thank both of you. They spent days and hours in preparing today's forum and presentation. I highly honor that this is a great example of community service and national service as well. Tonight, our moderator is Mr. Brian Song. Brian is a former federal prosecutor and a trial lawyer and a member of C100. He was the first speaker of this forum back in February. Also joining me today and to host tonight's forum is Professor Li Qiao from School of Aeronautics and Astronautics at Purdue University. And Li is a board member of the Combustion Institute International. Good evening, Li. And also joining me today is Professor Zhigang Suo, the Allen and Marilyn Pocket Professor of Mechanics and Materials at Harvard University. Zhigang, good evening. Thank you very much. Before we start the panel presentation, I would like to use one slide, only one, and to give you some background of this forum. The goal of China Initiative is to keep the US technology superiority over a foreign country. If we look at the US history of creating technology superiority, we have to remember this great man, Mr. Werner von Braun. He was the US rocket father, and he led the United States for the Apollo program and landed the first man on the moon. And he created the technology superiority for United States in space exploration and ended that technology competition from Soviet Union. Yet he was a Nazi V2 rocket scientist. And before he came to the United States, another giant man in space exploration, Mr. Chen, interrogated him and brought him to the United States. So here's Mr. Xuesen Chen. He was, in 1940s, he was a professor at Caltech. He was pioneered in the study of supersonics. He was a co-founder of Jet Propulsion Laboratory. And after World War II, he went to Germany, interrogated and Mr. Von Braun, and brought him to the United States. After he came back from Germany, he spent 2 years and in the government to develop a future US space program. Nevertheless, and due to that, the second Red Scare, the McCarthyism, that forced him went back to China and developed the China rocket program. He became China's rocket father. However, he did not want to leave the United States. He was forced to leave, according to the book by Iris Chang. History sometimes repeats itself. And today that the United States finds a new threat, that is China technology threat. So in 2018, the Department of Justice created a China initiative. The goal is to identify and prosecuting those engaged in economic espionage and intellectual property theft. Since the practice of the 2018 China initiative, the Department of Justice investigated about 2,000 cases and made a dozen arrests of scientists and several dozen of others, including on the left, you can see the two distinguished scientists, Professor Charles Lieber and Professor Gan Chen at Harvard and MIT. So these two scientists are the top scientists in the area of nanotechnology and energy sciences. So nevertheless, among that, the arrested scientists and others, only 3 of them are found that involved in technology espionage, and the rest are either misconduct or innocent. However, these investigations and arrests send shockwaves to the science community, especially for Chinese American scientists, and create fears of persecution and create the feeling that their national service are under question, and their loyalty to the United States are tested. And also at the same time, you create confusion within institutions. Every higher education institution is scrambling to develop a disclosure and training program for their faculty. And more importantly to this country, that we are losing talent. Some of the top scientists already quit their job and moved to another country. And some others are struggling to think whether they want to stay in this country. And others are scared to apply for government grant for research. And for education, for example, at Princeton University, in my aerospace department, our graduate student application from China dropped 10% from 2019 to 2000, another 30% in 2021. So we have to ask a question that, how do we establish US technology leadership and superiority? The question is that, can United States lead innovation without foreign talents and international collaboration? The answer is obviously no. As you can see that since 2000, more than 35% of the Nobel Prize winners in the United States are immigrants. At our time, the greatest innovator, Elon Musk, is also an immigrant. And then the question is that, okay, if China is indeed a threat, and how to conduct multinational collaborations in strategic areas such as artificial intelligence, biomedical, nanotechnology, energy, and climate involving China without any fears for scientists? And then next, can government develop a clear guidelines and a centralized training and disclosure platform for all government agencies, funding agencies? And third, should the new disclosure rules retroactively punish research collaborations previously encouraged by government and institutions? And fourth, to what extent is China initiative potentially undermine US leadership in science and technology by handing US talents over to China? And last but not the least, what changes to the China initiative do you expect to see under the Biden administration to make America greater? With that and the introduction and the question, and I would like to hand over that to the podium to today's moderator, Brian. Brian, please.
Thank you, Professor Chu. Again, welcome everybody to this webinar, which is a continuation of a series that I think the Scholars Forum will be putting on, the second in the series. I had the opportunity and privilege of presenting to you back in February about the general issues involved in the DOJ's China initiative. And tonight, with the help of Jay Bratt from the National Security Division of Department of Justice and Maggie Lewis from Seton Hall University, we hope to further the efforts of the Scholar Forum to make people more aware, to sensitize you and others about this important government initiative and some of the questions, concerns, issues, priorities, objectives of this initiative, and whether or not we believe they're being successful or not. So the format tonight will be that Jay and Maggie will each make a presentation short presentation, and then I will throw out some questions to them and have some crosstalk. And then we also have a period of time where questions from attendees to this program will send in their questions, and we'll make an effort to answer some of them in the time that we have.
I would first like to thank Professor Chu for his very gracious introduction. I'm very glad to be here today and to represent the department. I'm also glad to have had both the experience in preparing for this and what I'm sure will be a further experience in hearing from the members of this community. I know, and I think everybody knows, that there is a lot of skepticism among many in tonight's audience about what we have been doing with the China initiative and with our prosecutions. And I'm realistic, and I don't have any illusion that I will be able to allay all of that skepticism among even a significant portion of the audience. But what I do hope to achieve is to be able at least to demonstrate that as we carry out our cases, that we are doing so, we, myself, those immediately above me, our law enforcement partners, that we are doing so in conformance with our policies, our principles, and with good faith, and in good faith, and without any intent to discriminate. What I find helpful in talking about this subject, particularly to an audience that is not made up of prosecutors or lawyers or defense attorneys, is to start with an overall view of the context in which we work, how we're organized, what our responsibilities are, work through the threats that we see, and then end by talking about the China initiative, and in particular, a subset of cases within the China initiative, those that involve academic researchers. So I, as I've been introduced, am the chief of the Counterintelligence and Export Control Section, or CES, as we call ourselves, within the National Security Division. The National Security Division was created in 2006. It was a recommendation of the WMD Commission that all of the components within the Department of Justice that have responsibility for national security be resident within one division, so that there is a sharing of information, a certain synergy of operations. My office is one of two litigating sections within the National Security Division. We are responsible for the nation state threats and for insider threats. We have a sister section, the counterterrorism section, which is responsible for non-state actors, non-state terrorist organizations, both international and now increasingly domestic. We work in partnership with U.S. attorneys' offices. And again, this is a lay audience. So let me just briefly explain how federal law enforcement works. There is a U.S. attorney's office in every judicial district across the United States and its territories. There are 93 in all. And for the most part, each U.S. attorney who is presidentially appointed and Senate confirmed has a large amount of discretion about how he or she prosecutes within that district. There are exceptions, though, for, among other things, national security matters. Our cases tend to involve sometimes an expertise. It can involve foreign policy concerns. It can involve intelligence community equities. And for that reason, all U.S. attorneys' offices have to work with us. And we actually oversee, supervise, and approve a wide range of statutes. To jump ahead just a little bit, with respect to the fraud cases that we've been bringing over the last 2 years or so that involve academic researchers, those sort of fall within a gray area of our authority. The U.S. attorney's offices must consult with us, but whether or not they have to get our approval is sometimes up for debate. Now, for the most part, we work in tandem on these cases as well. I am familiar with every case that has been brought, but our office has been involved to different degrees depending on which case there is. So within my office, we have 4 main portfolios, and there's a deputy underneath me for each of them. The largest of the portfolios is counterintelligence. And that consists of traditional espionage, that is somebody who provides classified national defense information to a foreign government. It also involves the mishandling of classified information, the unauthorized disclosure of classified information, or commonly referred to as media leaks. We also do a large number of prosecutions, a statute that I have up here, 18 United States Code Section 951. We sometimes call it espionage light because oftentimes the people are not actually in possession of classified information. It's agent of a foreign government without notification to the Attorney General. Probably the most famous prototypical case of this sort, prosecution of this sort, were the Russian illegals, the individuals who came to the US, assumed fake identities, lived as if they were American citizens, and in fact were reporting back to handlers in Russia. We also handle economic espionage, which I will be talking a fair amount about in a little bit. And more recently, under this portfolio, are the research fraud prosecutions. Export control and sanctions is another one of our portfolios. That's really pretty self-explanatory. That's goods or services going to countries or individuals or places where they can't go without a license. We also have responsibility for all cyber prosecutions where they are state-sponsored or there are state actors. The criminal hackers don't fall under us, but the state sponsors do. And then finally, and this has been a growing part of our portfolio, is foreign influence. We administer the Foreign Agent Registration Act, so embedded within us is actually a small administrative agency, the FARA unit, which handles the registrations and handles the administrative and civil enforcement. But also there have been a growing number of foreign interference and foreign influence prosecutions, both on the FARA side and also sometimes using the 951 statute. And that too falls under us. Again, as I said at the beginning, we are responsible for the nation state threats. And it really should come as no surprise who the principal nation state threat actors are: Russia, China, Iran, DPRK, North Korea. And if you go across our portfolios, you'll see how each one takes up a certain amount of oxygen. In espionage, China, particularly over the last decade, has been very aggressive in seeking to recruit former members of the U.S. intelligence community. And I have 4 cases listed here, all of which were done within the last 4 years. 3 of them, the Mallory, Lee, and Hansen cases, were all pending at the same time, which is highly unusual. They all have been resolved. Mr. Mallory was a former CIA officer. Jerry Lee also was a CIA officer. Ron Rockwell Hansen worked for DIA. They all had very similar circumstances. Their post-intelligence community work lives were not very successful, and they were successfully recruited by Chinese intelligence. And then we have Alexander Ma, a case that we recently brought over the summer in Hawaii, and that's pending trial. Now, again, there have been other cases that we have done. Russia has been, not surprisingly, active in this realm, and we charged Peter Debbins over the summer in Virginia, who was spying on behalf of Russia, former special forces officer. He's pled guilty and is now pending sentencing. And we also charged within the last couple of years Monica Witt, a former U.S. Air Force intelligence officer who essentially defected to Iran and provided classified information to the Iranians and remains a fugitive. Agent of foreign government, we do see China very active in this realm. The Peng case was one that was resolved in the last year. He was acting as a courier for the MSS, Ministry of State Security, China's external intelligence organization. He received what he thought was classified information and would regularly deliver it to an intelligence officer from the MSS, who would bring it back to China. He received a 48 months sentence. There's also Dixon Yao, a case that was recently resolved. Mr. Yao is a Singaporean national. He had been recruited by the MSS, and he would travel to the US and try to recruit people in the defense industry, and was working his way to trying to recruit and obtain information from clearance holders. Another, what we think is very significant prosecution, which was brought within the last 6 months, the Zhu Feng case. Many, I think, are familiar with China's fox hunt effort, which is what we view as very bad conduct, where members of the Ministry of Public Security, MPS, come to the United States and try to pressure oftentimes dissidents, though China would say that they are criminals in China, try to pressure people who've come here as refugees to return to China. This case involved a couple that was in New Jersey, and they were wanted by the Chinese government. And they hired a private detective. The Chinese government, the MPS, hired a private detective through people that had co-opted in the New York area. They brought over the ailing elderly father of the husband of the couple, and he tried to pressure them to come back. They left threatening notes at their property, at their home. They threatened family members in China. And again, this is emblematic of some of the threats from China that we see. Now, again, other countries do similar things. We prosecuted Evgeny Beryakov, who was a Russian intelligence officer. His non-official cover was that he was an official at a Russian bank, but he too was trying to obtain sensitive, non-public information. He pled guilty. And we also recently prosecuted Majid Dustar, who was a US citizen, but living in Iran, and with his Iranian handler was sent to the United States to begin targeting Iranian dissidents and to come up with targeting packages. And he too pled guilty and was sentenced to 38 months. Economic espionage, which is the theft of trade secrets for the benefit of a foreign government, is another significant part of our portfolio. And here, really no other of the threat countries compares with China. The economic espionage statute has been used since 1999. 80% of all of our economic espionage prosecutions have had a link to China. 60% of all federal theft of trade secret prosecutions, that is, that don't have the element for the benefit of a foreign government, have a link to China. And as we have argued, and as I have said in other forums, it's not a surprise that China is so active in this realm. It's really very transparent as to its motive. If you look at Made in China 2025, which seeks to develop self-sufficiency, which is defined as producing 70% of components and technology in 10 key domestic sectors. I've listed some of them there. That is almost a roadmap or a motive for theft. China, as a newly emerged developing country, has made enormous strides over the last 20, 30 years, but it does not have the knowledge base and the technological base to succeed in all of these areas. And that has led to numerous cases that involve China. These are cases that come to us more or less organically. They come to us when industry will go to the FBI. They will see things as part of their own insider threat programs. They will see unusual activity on their computer networks. They'll see somebody emailing a large volume of data from a company account to a personal account. These are two of our cases, again, over the last few years. Mohai Long, again, I use this as an example because this is not a case where somebody was out looking for somebody who was Chinese, who was committing economic espionage. Instead, he was caught literally on his hands and knees digging up proprietary seeds in a guarded cornfield in Iowa, and then fled after he distracted the security guard that was trying to inquire about what he was doing. After he was charged, he pled guilty and was sentenced. Robert O'Rourke, another case that we did in Chicago over the last several years. Again, the common pattern, he is downloading large volumes of data, all of a sudden suddenly announces his retirement and is found to have a flight to China a week later. And he was about to start a job with a Chinese competitor. He too was arrested and prosecuted successfully. In the area of export control and sanctions, Iran is probably our biggest threat. Our Iranian cases represent 40% of our entire export control sanctions caseload. That was true before the Iran nuclear deal. It was true during the Iran nuclear deal. It was true afterwards, and I expect if we join the Iran deal again, it will remain true. China represents about 20% of our cases. DPRK has been an increasing, has taken an increasing share of what we do. Not so much in the terms of export of goods, but North Korea needs hard currency. And we have a number of prosecutions involving North Korea using front companies, many of which happen to be based in China or Hong Kong, to engage in prohibited US dollar transactions. And then Russia also comes online. State-sponsored cyber offenses, each of the countries really presents its own challenges. Russia, as everybody knows, has been very active. And the three cases I have here involve some of the malign uses that Russia makes of stolen cyber material, cyber information. In fact, it's interesting, in each of these cases, at least one of the defendants has been charged in more than one of the cases. And it involves, starting from the bottom, the Russia's attack on the World Anti-Doping Agency, and in sort of retaliation for Russia being excluded from the Olympics. Then at the top case, attacks on the Olympics, and then of course the famous Donetsk case, which involves the intrusion on the DNC and the hack and dump. The China cases are very much of a piece with the economic espionage prosecutions that we have. Almost all the China cases involve efforts to first do an intrusion onto a network of a company or institution, and then exfiltrate trade secret information, export controlled information. These are two very recent cases that we did. Iran similarly engages in that type of behavior. The case I have here, I would think is maybe of interest to this audience, because the Mabna Institute, which was the name of the sort of the cover name of this group of Iranian hackers, targeted universities not only in the United States but all over the world to try to get information that Iran didn't have. And then the DPRK is the state-sponsored robbery, and beginning, well, the Sony breach was also sort of retaliation, weaponizing information against an entity with which it had issues. But since then, the Bank of Bangladesh heist, cryptocurrency theft, has been the sort of the trademark of the DPRK. And then in the sphere of foreign influence, Russia is probably the leader in that. The Special Counsel Office's prosecutions of the Internet Research Agency showed how Russia was using various social media platforms, fake accounts, fake individuals to try to move portions of the US electorate We also brought the Butina case, who had come to the US to set up a sort of secret back channel, first with the Trump campaign, then with the Trump administration. It was in the news, the instances of Iranian cyberbullying during the 2020 campaign. We don't see as much of that type of foreign influence from China. Much of what China does is an exercise of soft power. But the case that I have here is one that also was of great concern to us. It was brought right at the end of last year, Xinjiang Jin. And that was an instance of, well, in the criminal complaint, the company is anonymized, but they outed themselves after the case was announced. So I think I can say it. It was Zoom, which some of us are using this evening. And Jin was an employee of Zoom in China and who was able to engage in activities that took down meeting rooms that dissidents and survivors of the June 4th Tiananmen massacre in 1989 were using to commemorate the event. He and others created alias accounts, and they would go to the compliance people at Zoom and say, oh, this particular meeting, they're talking about pornography, they're talking about terrorism, shut it down. And they were very effective over a period of several hours of shutting down the meetings of the dissidents. And we have a real interest in that. Again, notwithstanding some of the rhetoric about the China initiative, we also want to ensure that people who are here in the United States, whether they're citizens or they are on US soil, that they all enjoy the same First Amendment rights, that they have the right not to be harassed, the right to be able to express themselves without fear of consequences. And this was in this prosecution, we didn't use one of our core national security statutes, but we did use interstate stalking statute. And we would continue to look for opportunities to disrupt that type of conduct in the future. So now we come to the China initiative, which is the centerpiece of tonight's discussions. Former Attorney General Sessions, finally, one of the last things he did while he was still in office was announce it on November 1st of 2018. I think he resigned later that same week. It was done in conjunction with the unsealing of charges and a case called US versus Microelectronics Company, a Taiwanese company, and Fuji and Jinhua. And that prosecution is very much in line with how I described the Chinese efforts. Fuji and Jinhua was set up in 2016 to produce dynamic random access memory chips, DRAM. China had no DRAM production, no DRAM technological knowledge. Micron, a US company, did. Micron had a tiny Taiwanese affiliate, and some members of the Taiwanese affiliate stole Micron's trade secrets, went to UMC, Microelectronics Company, and then transferred that technology to Fuji and Jinhua. The Taiwanese company has since pled guilty and is cooperating. That case currently is scheduled for trial in August. Whether the COVID disruptions of court calendars will change that, we don't know. But the overall purpose of the China initiative was to shine a light on the threat that China presented. And I think if you look over, again, our various portfolios, when I've described as how the different threat actors, what they do in this realm, that China does stand out. And its primary purpose was, as I stay here, to prosecute economic espionage and trade theft cases, and to make sure that there were adequate resources, funding, staffing for those matters. Those matters, they're difficult in the sense that they take a lot of work. They're difficult in the sense that there's a lot of technical knowledge that lay people have to master. We saw, even before the China initiative, as we get referrals from the FBI, that there were more and more economic espionage / theft of trade secret cases coming, almost all of them with a nexus to China. Part of the China initiative is also to protect the US telecommunications network and supply chains. That's a different part of the National Security Division, the Foreign Investment Review Section. Part of it is to do outreach. I have here industry and academia, but also to the public, as I'm doing tonight. There was an emphasis on non-transparent and covert foreign influence. And actually, there has not been that much activity that we've done in the FARA realm, foreign influence realm, since the advent of the China Initiative. There has been the registration of the US agents of CGTN under FARA. There was one FARA prosecution with a link to China. That was the prosecution of Elliot Broidy, one of the people who, notwithstanding his guilty plea, ended up with a pardon at the very last day of the Trump administration. Part of what he was doing in this non-transparent lobbying scheme was lobbying on behalf of a Malaysian fugitive to have his case dismissed. But the second part of what he was doing was to lobby on behalf of a high-ranking official in the Ministry of Public Security to obtain the expulsion again, of another individual that China wanted who had fled to the United States. And that involved lobbying the Department of Justice, Department of Homeland Security, and through a very influential and powerful Republican donor, the president himself. And Mr. Broidy, at least for a time, was being held responsible for that. Also part of it was to develop an enforcement strategy for non-traditional collectors, which I am about to turn to, and to improve law enforcement cooperation with China, which, to be honest, has been a black hole. There's been very little appetite, really on both sides, for law enforcement cooperation over the last several years. So what are non-traditional collectors? They are individuals who either wittingly or unwittingly aid a hostile state. It's not necessarily their purpose to do so. But they can become assets of intelligence service. They can become assets of a foreign government. And China, again, very openly makes use of non-traditional collectors. And in the science and academic realm, it is primarily through the talent plan programs, and they're a key recruiting tool. We make very clear that we do not consider merely being a member of a talent plan program something that's per se illegal. But the talent plan contracts, those types of relationships, can create incentives for conflicts of interest, conflicts of commitment. So why do we do these cases? And what is our interest in doing so? The key values that we are really trying to protect are transparency, integrity, norms, academic norms, scientific norms, ethics. There is a disruption element to it. These are cases that can sometimes stop harm before it becomes, stop conduct, I should say, before it becomes more harmful. A key part of what we are doing or trying to vindicate is the integrity of the grant-making process. And again, I'm probably saying something that everybody in the scientific community knows, that more grant applications are rejected than are accepted. NIH only accepts about 20% of the proposals that are submitted to it. And there is a real harm in a failure to disclose foreign obligations and affiliations. It deprives the grant maker, as I say here, of an objective choice of whom to fund. If somebody lies on the conflict of interest forms, that calls into question the entire integrity of their research. Because if you're willing to lie about one thing, you're possibly willing to lie about another thing. And it also deprives universities and research institutions of the ability to have a stake, an equity stake in the technology that's being developed. We have about a dozen cases that are currently pending. Very important thing to know about these cases that they all require a proof of an intent to defraud or to make willful lies. And these are elements that we have to prove beyond a reasonable doubt. Fraud cases, because I know we were talking in our preparation for this session, well, these are sort of easier, low-hanging fruit or easier cases to do. They really aren't. Anytime you have to prove somebody's state of mind to a jury, that's a difficult task for a prosecutor. I remember the very first fraud case that I tried to a jury, and was thinking to myself, why can't this be a drug case? And a drug case either he has the dope or he doesn't have the dope. But here I have to show what was the defendant thinking. We do not, and we really cannot prosecute people for inadvertent errors. We have to show an intent to defraud. And in the cases we brought, we have not premised any of the fraud charges just on the failure to disclose talent plan membership. We are looking for conduct that is more egregious. We are looking for an awareness on the part of the defendants, not to talk about a specific case, at least of the pending ones, but the types of evidence we have, our communications, where the professor will be saying to somebody in China, my university can't know what I'm doing here once I begin work on this project. Another case, communications along the lines of, I'm not quite sure what I can do. I now have two jobs. I have this job in China. I have my job at the university. How am I gonna reconcile the two? How am I gonna thread the needle of being two places at once? That is a recognition that what they are doing is illegal, and those are the types of cases that we've been trying to bring. Also, in some of the cases, there are a couple that we've done where it's lying in the course of a federal investigation. We always take that very seriously. Again, not to get into some of the political controversy about the pardons in the cases, but if you look before the pardons, Michael Flynn, George Papadopoulos, Alex van der Zwaan in the special counsel's office, they were all prosecuted for lying during the course of their investigations. One case that I can talk about of the ones we recently brought, since there's now been a guilty plea and there are now facts in the record, is the prosecution of Dr. Song Jen, an immunology professor at Ohio State, who soon after being fired by Ohio State was arrested as he was about to get on a charter flight to China from Alaska. And his conduct was egregious. And these were the sorts of things that, because I know Brian will talk a bit about a GAO report on conflicts of interest and what grant making agencies require or don't require. But these are not, confusion about affiliations. This was somebody who was receiving salaries from several Chinese universities and from the National Natural Science Foundation of China. And again, at least our witnesses would say, anybody in this field would know that that's something that you have to disclose. He had arrangements and money and equity interest in a number of firms that did business in the same field in which he was researching. He failed to disclose patents that he had. That was the type of case that we bring. There's the Lewis case. The professor in West Virginia University, really just outright fraud. I mean, he told his university that he needed to take advantage of their sort of parental leave program because he had a newborn child, which was true, that he had to care for, which was false because rather than care for the child, he went to China and taught and still was getting his salary from the University of West Virginia. And then the Lookman case. I mean, this is one where, yes, the only thing in there is his statements about talent plans, but he made those false statements in the course of a federal investigation, and we prosecuted him. I'll close with the Justice Manual, which is our set of guidelines as to how we are supposed to conduct ourselves. And this is from the Principles of Federal Prosecutions. You can read it to yourselves, but if you look at the cases that I've described under this, does say the prosecution of Song Jen, does that serve a substantial federal interest? I would say yes, that he cheated his university, cheated the grant makers. There were two different grants that he had from NIH. By the lies that he told. Is it subject to effective prosecution in another jurisdiction? That doesn't really arise in these cases. I mean, I guess some state prosecutors might have an interest, but we really don't see that. And then last, is there an adequate non-criminal alternative? And I know Brian and Professor Lewis will be making arguments along those lines. To foreclose maybe some questions that will come in because there have been things in the media about an amnesty plan. There currently is no amnesty plan that the department has, and to the extent there may or may not be internal discussions, that's not something I can discuss. But if you do look at some of the voluntary self-disclosure programs that we have, and we have one in my section that we administer for corporate disclosures about export control and sanctions violations. There's a carve out for egregious conduct. And when the conduct is of the sort, again, as Dr. Zhang engaged in, that is something that with a China initiative, without a China initiative, we would always prosecute. With that, I think I've probably more than used my 20 minutes, and I appreciate having the time, and I look forward to your questions.
Thank you so much to the Chinese American Scholar Forum for hosting and to Jay Bratt for participating. I hope there will be more conversations like this. I also want to thank Brian Sun for moderating. And I am in Taiwan, and we figured out that Brian and my kids are Xiaoyou because he too went to the Taipei American School. So in the next 20 minutes or so, I want to address a couple different things about the current situation, but where I want to start actually is about 20 years ago. Some of you might remember there was a fad in the 1990s for Beanie Babies. They were all the rage. At that point, I was actually working for a law firm in Beijing that was representing Tai Inc., the maker of Beanie Babies. And we were working both with the Chinese authorities and the US authorities to try to stop the flood of fake Beanie Babies coming into the US. It got to the point that even Charlene Barshevsky, then the US trade representative, got in trouble because she violated the rule of bringing in more than one Beanie Baby. Now, what was interesting was how we did at that point have some cooperation with the Chinese government. And in fact, they took a big pile of fake Beanie Babies once and took sort of a military tank-like vehicle and rode it over the Beanie Babies. And one lone Beanie Baby was going around the treads. I was not allowed to attend in person, only our Chinese colleagues, but they brought back the video. And I say this because it was such a different time. And that kind of cooperation certainly is much harder today. And that dispute seems cute, literally and figuratively by comparison to where we are now. And I do think it's important to recognize how different 2021 is, even different than 2011 or 2001. We have a much different relationship with China, and that's both in the Department of Justice's China Initiative and more generally. So I'm gonna give a little background, but most of that was covered already, and then explain why I think the China Initiative is problematic. And then finally, I'll think a little bit about the future. I, of course, have no say in the future, but as an academic, I hope that we can get some suggestions out there that perhaps as we wait for hopefully Attorney General Merrick Garland in the next week and his deputy, we hope Lisa Monaco will be in soon, but what might happen once they are in place. Now, as background, as was said, this was actually, it began in 2018, but these concerns predate its creation. And there were already instances under President Obama that look very similar to the kinds of cases that have been brought under the China Initiative. And the initial focus when Jeff Sessions stood up at the podium was on economic espionage. And again, this is trade secret theft when the intended beneficiary is a foreign government or an instrument thereof, something tightly connected to that foreign government. And there is clear evidence that the PRC party state is directing some activities that are illegal under US law. And already was mentioned the Dixon Yao case, and he pled guilty last year to acting as an illegal agent of a foreign power. Now we have this increasing concern for these non-traditional collectors. These are people who don't look like someone in a John le Carré spy novel or a Tom Clancy novel. There's academics, students, business people, those sorts of concerns. And again, we have this talent recruitment programs, which were already mentioned. There was the 1,000 Talents Plan, and there's other names. And these provide incentives to people who have expertise that is beneficial to the PRC party state's goal of increasing innovation. And just the last couple of days, when the National People's Congress has been meeting in Beijing, we're seeing this increasing emphasis on indigenous innovation and how to increase China's competitiveness so that intellectual property, that IP, will be all the more important. Now, again, this is not a crime under US law just to participate. So I want to go to the Gang Chen case. This was the initial criminal complaint. It was filed in January, and then about a week after this, the indictment was issued. So this is essentially sort of the first version of the charges that was supplemented by the formal indictment. Now, when you look at the complaint, it has this footnote 4, and this key sentence being, While participation in a PRC talent program is not in and of itself illegal, the failure to disclose an affiliation with a PRC talent program in an application for federal grant funding may, as discussed below, violate one or more laws. That you're getting into a zone where you need to be very careful that you are then dotting all the I's and crossing all the T's. And finally, then we have the indictment that was issued on January 20th. And here the charges were wire fraud, failing to file a foreign bank account report, and making a false statement on his tax return. So no actual claims that there was attempted or actual transfer of protected intellectual property, but rather these are non-disclosures and false statement sort of claims. Okay, so what we're seeing overall, and this is not just in the China initiative, is this increasing securitization of the US PRC relationship, that national security concerns are on the rise across the board. We saw this under Trump, it's continuing under Biden, it is expected to continue. I'm in Taiwan, trust me, I am concerned about the military and security side of the PRC's ambitions, as well as the economic side. Also that, we know that prosecutorial discretion is vast, and this is not particular to the China initiative. If you talk to anyone who does work in criminal law, they'll tell you there's a lot of conduct out there that might be technically illegal, but either doesn't get discovered or it does get discovered and it's not a priority and it's not prosecuted. So prosecutors make choices all the time about the types of conduct they're going to prioritize. Now, we also know that getting information on the Department of Justice's cases involving links to the PRC is difficult, that those of us on the outside are frustrated because we have limited information. This is first because, it's criminal law in general, it's hard to sometimes get information, but the national security context makes it so there's even less transparency. And then on top of that, because most of these cases are being resolved through guilty pleas, we aren't getting the information you would at trial. Several cases are headed to trial, and that will be interesting to see what kind of information comes out when there is much more public scrutiny. Also, I think it's fair to say that this China initiative has increased security consciousness among researchers. We wouldn't be having this webinar. A lot of people wouldn't be tuning in if they weren't concerned about the China initiative and what it meant for their work. And my question then is, has the pendulum swung too far? Has there been too much emphasis on the national security angle? So what's our challenge? How can the US government address two real phenomena? Both of these are going on. There is threat by association attaching to people who are viewed as connected to China, as in the China initiative. And there are threats from the PRC party state that go beyond traditional spying. Now, I use PRC party state because when you look at the talent plans, some of these are emanating from the formal Chinese government, the PRC government. Others are more embedded in the Chinese Communist Party structure. Anyone who studies China knows that the official party structure and the government structure are intertwined in a very complicated way. It's hard to disentangle oftentimes when are you dealing with the government and when are you dealing with the party. So I've written a very long article. You're welcome to pull it up and read it. It's available now from the Journal of Criminal Law and Criminology, looking at the China initiative, both about why this China of the China initiative is very broad, and also how the initiative stacks up when you look at the goals that the Department of Justice sets for itself as far as why we punish people. And so I argue in there that using China as the glue connecting cases prosecuted under the initiative's umbrella creates an over-inclusive conception of the threat and attaches a criminal taint to entities that possess what I call China-ness. It might be PRC nationality, PRC national origin, Chinese ethnicity, or other expressions of connections of China. And by that, for example, there's been several press releases where the person being prosecuted is not ethnically Chinese or from the PRC, but it'll say that the person speaks fluent Chinese. That is not directly relevant to the crimes being charged, which makes me wonder why sometimes it's emphasized in the press release. So already mentioned was the Department of Justice's Justice Manual. This is the manual that sets the standards that the Department of Justice has for itself. And importantly, it says in determining whether to commence or recommend a prosecution or to take other action, the attorney of the government should not be influenced by, so this should not even be an influence, including ethnicity and national origin. So we're trying to figure out how can we make sure that those those factors, what a person looks like, where they're from, are not playing in, aren't even influencing the decisions being made. Now, when you look at the China of the China Initiative, I want to be clear that speaking in terms of US and China, that fits the realm of state-to-state relations. If we're talking about a bilateral trade agreement, if we're talking about a mutual legal assistance treaty, then put US and China on it, because those are the state entities that are involved. I think it's a more uncomfortable fit when it's applied to individual prosecutions. Why is that? Because when you look at the rhetoric of the China Initiative over the last couple years, China oftentimes is painted as this sort of anthropomorphic threat, that China's malign behavior, or when China steals our intellectual property. Of course, China itself cannot steal the corn seeds or the robot arms. Individuals or legal entities, so this could be people or companies, they're ultimately, of course, the defendants in these cases. But yet, oftentimes, we've seen the US government, and this isn't just in the Department of Justice, certainly the State Department, former Secretary of State Michael Pompeo and others made these, oftentimes claims about what China is stealing. And I think that creates this sort of existential, amorphous threat that is looming over the United States. Now, and the other thing that I worry about is that the statements under the Trump administration emphasize the communist in Chinese Communist Party. In fact, when Gang Chen's, when his charges were announced, the FBI, one of the FBI officials in Boston, kept talking about the Chinese Communist government as, conflating Chinese Communist Party and the formal PRC government. Yes, they are, enmeshed, but I think the more that this idea of the communist is emphasized, which again, if you study China, it's certainly not textbook communism, it can stir fears that are deep-seated and not necessarily keeping us focused on the facts of the cases. We also saw the mention of whether there was issues of loyalty. Gang Chen is a naturalized US citizen, and asking, this is not about money, but actually having the former now US attorney for Massachusetts saying it's about his loyalty to China, which also concerns me if we start questioning people's loyalty to the United States as part of how we describe these cases. Another example, in one of the FBI's publications about China, the risk to academia, it does recognize the benefits of having people from China, but then it talks about how foreign actors who do not share our rules or our values. So there's a tendency to other, that there's something about people outside the US that is threatening. And also we have to be recognize that even though the China Initiative was started before COVID-19, it is completely unrelated, that we have these really negative views of people who look at all Chinese that are happening in the US, and then makes it so I think it's incumbent on the government to be especially sensitive to these issues about affected communities. And so here this is the FBI publication that I just cited. You can see some of the visuals too. Okay, now you have also this idea of increasing threat awareness, and the US government has done a series of films. Now, the Game of Pawns was the first one. This was under Obama, and it was about a US student studying in China who got recruited by the Ministry of State Security. We had a dramatization also under President Obama, The Company Man, of a man at a US company who got recruited to sell secrets. And then most recently, just this fall, The Nevernight Connection. Similarly, having someone who was a retired US military employee, then get involved with some Chinese operatives in selling or attempting to sell secrets. But when you watch these films, the images and the depiction, there's a lot of stereotypes and a lot of tropes that I think are feeding more fears than actually educating people to the threat in a way that is as targeted and as responsible as we should be. And so here too, we think about, what is the goal? It is this, raising consciousness of the threat and getting people to avoid behavior that's going to compromise US economic interests. But here a statement by Adam Hickey, and in the second paragraph, he starts out, while there is a presumption of innocence in the criminal context, we are here today as risk managers, not as criminal lawyers. But the more we look at this as just generally trying to slow, the risk, I think we lose again that individualized lens of making sure that we don't conflate individuals with a more sort of amorphous threat from China. And this leads me to, I go into great details in my article. And I want to be clear that there is no evidence, at least that I've seen, that anyone in the Department of Justice has said we are going after anyone in particular because they are Chinese, have a PRC passport, have any ethnic, connection originally to China. And it might really just be there is a higher prevalence of activity. But we can't really prove or disprove that because we can't get the data. And even if we can't put this down with a regression analysis to there being a higher rate, we have to recognize that there is palpable stigma among Chinese Americans and PRC nationals resident in the US. That is their lived experience, and that should concern us regardless of whether we can prove this definitively with any data. And the statements that are often made by the US government that the China Initiative is being conducted in a non-discriminatory manner have not been accompanied with any really explanation of what work is being done by the US government to make sure that there is not bias creeping into the way that this initiative is being carried out. So what do we do? And let me be clear, we all have biases. We all have them. Some are explicit, some are implicit, but they're at work. If you've ever taken an IAT, an implicit association test, this has probably been made apparent to you. And simply requiring people to sit through a few hours training is not the way to answer this. In fact, what we're learning is that mandatory anti-bias trainings can actually can backfire and make the situation worse. So what we need is a holistic approach to mitigate bias to make sure that we are making decisions in ways that that's not creeping into our choices. And the American Bar Association has already done quite a bit of work showing how implicit bias can influence prosecutors' decisions, and they have a toolkit that they've pushed out to try to help mitigate these issues. And I also go into, again, in deep detail in my other work, and I don't have time here, but as mentioned, the clear aim of the China Initiative and why people are being punished is, yes, they've done things wrong. You can say they deserve to be punished, but in addition, it's deterrence. We want to discourage possible offenders from committing crimes out of fear that they will face a similar end like defendants like Professor Chen. And then we have to ask, when is deterrence over deterrence? So are we using the heavy-handed use of the criminal law? These are penalties that could be years in prison. Could they hurt the United States' economic competitiveness, both by chilling research by Chinese Americans and reducing the flow of talent from the PRC to the United States in artificial intelligence and other critical areas? We've seen nanotechnology as one that's focused on. So then can we create, or are there already in place, adequate non-criminal alternatives to prosecution? And again, I go back to the exact same part of the Justice Manual and that part 3 that was already mentioned. There exists an adequate non-criminal alternative to prosecution. That is something which, even if we don't have them now, we need to think about: when do we want to use criminal law, actually lock people away, and when are there ways to deny them future grants or have administrative penalties that might achieve similar effects without the negative externalities? I just want to point out a recent study. This was an opinion panel survey done by PsyOps. It's based at Arizona State University. This whole thing will be posted, and so if you go back through and watch the video later, you can pause on the slide or go there. And I just want to make sure people understand this was a real survey. It wasn't just anecdotal asking a few scientists. But what was interesting, what they found based on asking scientists just last year, just came out, was that overall 37% of scientists have considered moving outside the United States. Nearly half of non-US citizens reported considering moving to another country. And really importantly, more than half of scientists, 61%, say a major reason for considering a move is they no longer feel comfortable in the US because of political rhetoric. That's a huge percentage. That's really worrisome for our competitiveness. So what about the future? What might happen? So I think it's clear that the China Initiative has raised the security consciousness of researchers. They are more aware of having to take into account all of these considerations in their work. However, I think it's swung too far towards the securitization of the relationship. And the protection of US intellectual property would actually be better served by a more carefully calibrated approach. So what would that be? I'm going to throw out some suggestions. Hopefully we can talk about them in Q&A and going forward. And some of these are already underway, but I think they could be enhanced even further. So first of all, I want to see the end of using the title, the China Initiative. This would signal a clear break from the Trump era inflammatory China threat rhetoric and see more of a shift to a country neutral framing in the way it's discussed. That means that there could still well be, I fully expect, proportionally more cases involving the PRC. I'm not saying you need to show a case from Bolivia and Tanzania and Poland, but it does matter that you have this, we are looking for compromising IP or people who have shadow labs or whatever might be the concern, and then follow those cases wherever they may lead. And I think it would also be a clear step in saying we want to diminish the stigma, which is real. Second, continue to expand coordination across the executive branch. The Department of Justice, my understanding is there's not really deep country expertise. They're gaining it, or linguistic expertise, and also better technical expertise. I'm really excited that the Presidential Science Advisor is now a cabinet level position, and that just in general, the Biden administration is showing more interest in understanding and using science. So how can we, and I know this is easier said than done, work across different parts of the executive branch to bring in the expertise that's needed? And here I would point you to just at the very end of the Trump administration, this presidential memo came out on supporting research, development, national security policy, and it's got a lot of good stuff in there. And so I hope that that's being looked at carefully and acted on, even as we shifted administrations. Third, I want to see more cooperation with those of us outside the government, the scientists who can further assist law enforcement to understand the benefits and risks. Certainly the Gangchen's initial complaint and the changes between that and the indictment showed that there was, I think, some, if not misunderstandings, at least not enough knowledge of sort of how sometimes grants work and how the science process works, and that could be enhanced by working with that community. People who study the PRC legal system to understand better when are there really ties that we want to be concerned about. For example, Andrew Lelling, when he was at the US Attorney for Massachusetts, he made comments about if you give your information to a Chinese company or university, you've given it to the Chinese government. It's more complicated and nuanced than that. And then third, I'd like to see more work with criminologists to try to figure out when are we trying to hit that better spot, even if not a sweet spot, to get deterrence of the bad activities, but be able to keep the international collaboration we want. That's hard, but there are people who are much better at trying to look at that data and could give us some better answers. Fourth, work with universities to streamline and clarify grant compliance procedures, and also across the different bodies, like NIH, because even though it is true that you need to prove with these most of these charges intent, the clearer the requirements are and the less onerous the paperwork, the more apparent it will be when the non-compliance is due to intentional evasion rather than relatively benign reasons. Let's make it so prosecutors have a much clearer job of showing when this was intentional and when this was more, if not totally benign, at least less nefarious. Fifth, and this is my last, collaborate with Asian Americans and PRC national communities to understand how they experience discrimination and construct programs to enhance diversity and mitigate bias, that those go hand in hand. And because ultimately the US is best off, not just that if we protect the IP we have today, but that we have a continuing stream of new intellectual property to protect. And that requires training, recruiting, and retaining the best minds, regardless of where they're from, what bodies they're in. And here I would point to, there's a readout on the Department of Justice's website just dated March 5th about a meeting that John Carlin had with AAPI communities. And that being a listening session. I would emphasize too that a lot of the focus has been on AAPI communities, Asian American and Pacific Islanders. That's great, but we also need to discuss the citizen communities. People should not have to wait to be a US citizen or have a generation and have kids here for them to be protected. So we also need to protect the people who are foreign passport holders, but are here working legally. And just the last thing, I'm excited too that I just saw that the Truman Center has put out a report about transforming the State Department, thinking about ways to enhance diversity, equity, inclusion. And I think there's a lot in here that might also resonate with the Department of Justice. And so we should think about what lessons we might learn from efforts going on in other parts of the government too. So with that, I think I've gone over somewhat. So I will hand it back to Brian.
Thank you, Maggie. And I guess Yiguang and let us know when we need to start the Q&A from the attendees, and I will, but like to take some time here and focus on some questions to the panelists. I think those who attended the last one we did will remember the history surrounding some of these things that we've discussed. Maggie talked about the fact that these cases predated the Trump administration. And in the last presentation I did last month, we talked about the historical discrimination that Chinese Americans had experienced over the centuries, literally. And more recently during the Red Scare in the 50s, when Professor Chen went back to China because of a lot of hysteria directed towards the communist threat at the time, and then campaign finance some 20-something years ago, which led to the initial focus on Chinese technology and congressional inquiries looking at the objectives of the Chinese state to try to obtain US technology. Many of you know about the Li Wenhe case, where which sort of started this modern, was the genesis of these cases that we see today. When you go to the China Initiative today, and we've talked about this in some of Jay's presentation, about developing a strategy towards non-traditional collectors, researchers in labs and universities, and educating colleges and universities about these threats. Somehow that morphed into a number of criminal investigations that are pending now, prosecutions that Jay talked about, which I think I want to throw out to the two panelists about why we are criminalizing this in the context of the academics, recognizing that what the objectives are with the China Initiative. And most particularly, I want to talk about in some of the questions here about the impact not only on the academics, tenured professors and the like who receive funding, but the postdocs who study with them, who many are suggesting now should not, that are now being singled out by the DOJ for visa fraud prosecutions, these postdocs, whether or not that again is a possible overreaction to the problem stated by the government. And as I pose questions to Jay and Maggie, the case of Professor Chen out of MIT is one that I think I observed in the last talk represents a sea change in terms of sensitivity and awareness, as well as Professor Lieber's continuing insistence that he's been singled out too. And of course, Jay did respond to this issue of whether amnesty is in the cards here or not. And I will say this, to start my questions here with Jay and Maggie, is this whole issue of criminalization of this conduct versus educational awareness. I had in the past ventured into Maggie's area and taught white collar crime at a law school. And one of the key topics when you talk about white collar crime is, when do you criminalize certain activity? And Maggie, you posed some of the DOJ guidelines that govern the exercise of prosecutorial discretion. And so the first question I would ask to Jay would be, why criminalize this conduct by these academics versus focusing on educational awareness and trying to sensitize professors and academics of the concerns of the Department of Justice and why they should be wary of their ties to China, be they through Thousand Talent programs and the like. Why criminalize it as opposed to trying to educate, sensitize, and warn these academics and researchers of the perils of engaging in activities that could get them criminally prosecuted?
So I think we try to do both. We try to make people aware of what the pitfalls are. We try to make the institutions aware of the challenges they face. But at the same time, and maybe I've been doing this so long that I become a bit hardened, but we really aren't self-reflective in the way of thinking when cases come to us. Is this something that we should be quote unquote criminalizing? I mean, when cases come to us and the types of questions that we ask are the ones that involve, can we make out the offense? Is the evidence there? Is the conduct sufficiently egregious that a jury would be offended by it, that a judge would be offended by it and seek to impose a commensurate sentence? In some ways, once the case has gotten to us, it is already criminal in nature. And that's our jobs as prosecutors, is to prosecute cases that fall within, again, fall within our guidelines. It would be good if we could, have some prophylactic effect and try to stop them at the outset. And I know that, Brian, you counsel your clients, and that there's likely to be another webinar involving defense attorneys that are going to give some general guidance as to how to avoid these pitfalls. But like, once something gets to me, it's already gone through those hoops, and it's already at the stage of, is this a case that's worthy of prosecution? There are cases we decline. There are cases that come and, no, this is not a criminal matter. This should not be dealt with criminally. And I think in some realms, we'll have frustration from agents where, they've put a lot of time and effort into a case, and we'll say, it's not there. We can't prove the criminal state of mind. This should have, if it's available, an administrative resolution or a civil resolution. This is not a criminal case. But again, once it, especially with these types of cases, for the most part, the ones that I have seen, they meet the threshold. And they are brought to us in the context of a significant concern, both not just the national security concern, but from our partners in the Inspector General community and in the grant makers, an academic integrity issue.
Maggie, let me flip this side of the equation to you. There are some who subscribe to the view, me being one of them, that the impact of some of these cases is having the opposite effect, in the sense of many of the professors who have been subject to either investigation, scrutiny, or some criminal prosecution have concluded that they're no longer welcome here in the United States and are returning to China to practice continue their research and all that, and that America, the United States, might in fact be hurt by the loss of this brain power, this talent, and that in fact the objectives of the China initiative may be backfiring on us, so to speak. Do you have any views or on this particular position?
And I want to make clear that people are not feeling welcome in the U.S. just because of the China initiative, that there is so much more going on. And you just look at the spike in hate crimes, and a lot of those, it's nothing to do with the China initiative. But there is a climate right now in the United States that is not welcoming of people who are foreign, and particularly who are seen as having ties to the PRC. And that makes it so the Department of Justice should be particularly sensitive. And then when we look at the community of the researchers, of the scientific community who are creating what we need for the U.S. economy to thrive going forward, I think right now is a perfect time with the change of administrations to do that, tap the brakes and ask, has the China initiative achieved its goal of getting this out there in the neon sign that we're worried about being compromised by non-traditional collectors, about the Thousand Talents plan being a conduit for important intellectual property going to China, and then asking exactly exactly what you're saying. Have we gone too far? Have we made it so we're actually shooting ourselves in the foot? And I would add to this that, you know, you look at what also happened in the Trump administration with ending, for example, the Fulbright program with China. The reason that a lot of my colleagues, I did my Fulbright in Taiwan, but a lot of my colleagues know about, you know, how the PRC government works is because they spent time in country. So we need to make the US welcoming for people from China, and we need to make sure the US understands the PRC, and that's another part of this equation.
Jay, let me tackle this. One question was raised by both of you, essentially, which is, you know, nobody has probably a problem who's attending this webinar, or even the panelists or speakers, even if they have different views on its the impact of the China initiative. No one quarrels with the notion that many of the cases brought by the National Security Division involve defendants or actors who are doing just bad things. I don't think anybody has a problem with that. But in entering the realm of the academia, where by definition, the players, the researchers, the academics are in a business of trying to do research that involves collaboration with colleagues within their own institution, other institutions in the United States, or even worldwide, colleagues or scientists in France, Germany, Taiwan, Japan, China, that there's a sense that the China initiative is interfering with proper collaborations, and that researchers are feeling they're feeling caught in the middle, so to speak, of what they've been asked to do by their school, asked to do just by their own nature of their occupation and profession. And how do they navigate through that? Particularly if the researcher has or scientist has a counterpart in China who has the same objective, that they share these same objectives of wanting to further research in a particular area that could better the lives of our children. How is it that the US government's China initiative is such that, are they saying to these researchers, cut off these collaborations? How do you navigate through this world and do your job when the people you would work with normally and would trust and share information with to try to further science are being told that I could be criminally prosecuted if I do that? Do you have any suggestions or advice for the attendees here on how they navigate through this sort of treacherous minefield, if I can call it that?
First, I would say, and I don't think this is a fanciful assumption, but I'm going to assume that most of the people here would not succumb to temptations to bend the rules for their own personal benefit. And while there may be concerns about, if I disclose this or I disclose that, I may not be able to work with this person, or I may not be able to have the opportunities in China or somewhere else, that the better practice is to follow the rules. And it's my understanding from the grant making organizations that yes, there are some conflicts that are disqualifying, and that would cause the grant making agency to say, no, we are not going to fund this because there is overlap, complete overlap with the other funding source. So why should we pay for it if somebody else is going to pay for it? Or it's a situation where the researcher may, again, have a stake in a business in the foreign country. And because of that opportunity for personal gain, it calls into question the objectivity of the research. And the grant making agency is not going to want to fund somebody in that situation. But if it is a true collaboration and that there is not an overlap of funding and other conflicts of interest, then there should not be a fear in disclosing that to the grant making organization, because that shouldn't be disqualifying.
I would just add that I think that, this idea of an amnesty, of a voluntary disclosure program is interesting and should be explored to try to make it so people have some comfort if they have done something which they think might be on the line. And also that could generate a lot of information for the government about what's been happening. I would also be curious to think creatively going forward, in addition to making the requirements, again, as clear and streamlined as possible. Is there some way to take a page from the playbook of the SEC and sort of no action letters and have people be able to ask before entering into some sort of collaboration? Here's what I plan to do. If I do this, where am I going to land on the line? Because again, we want to create incentives so that the U.S. comes out of this ahead economically. And right now, I haven't seen any math that's saying the China initiative is hitting that spot that's allowing those productive collaborations to continue. Instead, I'm hearing a lot from the people in the community who are ethnically Chinese, I am not, about their lived experiences, which are very, very worrisome, as shown up in that recent poll about how many find the political rhetoric is even making them think about leaving the country.
Jay, you mentioned a moment ago to talk about the importance of complying with the rules. And you made earlier reference to a GAO report, which I want to bring up at this point. For those in the audience or attendees who don't know, that in December of last year, to 2020, the Government Accounting Office, GAO, at the request of Senator Grassley, I believe, of the Senate Finance Committee, had been asked to undertake a study of the way in which the federal government agencies that fund academics and researchers in this space, mostly the STEM fields, have been handling the enforcement, interpretation of the rules that apply to obtaining information from grantees or prospective grantees on their ties with foreign countries or those that could be susceptible to foreign influence, and most notably focusing on foreign influence from actors like Russia, China, Iran that could be impact the national security. This report, which came out a few months ago, had some interesting findings and conclusions that I want to bring up to Maggie, you and Jay, in terms of the context of the rulemaking and enforcement of these rules. And I think these issues have come up in Professor Chen's case out of MIT, Lieber, Harvard, and other professors around the country now who've been under investigation, who are complaining, if you will, if I can put it out there, that the rules have been less than clear, that the way in which the grantees or the prospective grant applicants have been asked to fill out the forms were susceptible to questions that were less than clear about what the agency was trying to elicit from the grant applicants. And in fact, the GAO report seems to provide some substance for the conclusion that these rules have been less than clear, that the agencies in question, and I'm going to go into them, acknowledge in essence that there were problems with the way in which they, the agencies published their rules, interpreted them, and all that. And so, and I would say for the record that the key agencies here, I believe, and I could be wrong, are the Department of Energy, the Department of Defense, the National Institute of Health, National Science Foundation, and NASA. Those 5 primary agencies were queried or audited by the GAO in this context. So I would ask you, Jay, first, for your views on that report, and to the extent that it would it not support the notion that grantees, including many of the people who may be attending this webinar, could easily be confused when they fill out these questionnaires or these grant applications that have questions designed to ferret out conflict of interest, both financial and non-financial, and lead to some confusion. And so I know I'm asking a compound question, so as a trial lawyer, forgive me, but assuming there is some confusion here, is it fair to criminalize conduct in this space when the questions directed to these scientists or grant applicants are hardly clear, or seemingly by the government's own recognition and by acknowledgement of these agencies is less than clear? So again, I am asking a compound question, forgive me. How is it fair to go after them? And because these agencies have in fact recognized there's some problems with the way the questions were posed to them on these grant applications.
So Brian, I know that you've spent more time with the GAO report than I have, but as I understand the report, where it was critical, and it was primarily critical of DOD and DOAE, not NIH, NSF, and NASA, but where it was critical was a lack of clarity or standards on making disclosures as to affiliations. So in other words, if somebody acts as a consultant in an unpaid fashion for a foreign research institute or university, is that something that you have to disclose? However, and you can correct me if I'm wrong, but as I read it, it did not call the grant-making agencies to account for lack of clarity on the issue of financial conflicts of interest, and that it is clear across the agencies that if you are receiving funding for the identical type of research, if you are receiving a salary from a foreign institution, if you have an equity interest in a foreign business that is seeking to profit from the technology that you are working on, that it is clear and always has been clear that those are the types of conflicts that you do have to disclose. And as I was the point I was trying to make in my portion of this was that those are the types of cases that we've been trying to focus on, and not the cases where the sole failure is the sole wrongdoing is the failure to disclose certain affiliations.
Maggie, do you have some views on sort of the question here of whether or not the regulations that the DOJ has been enforcing in the criminal context here and the rules that Jay has referred to are perhaps subject to some degree of re-examination in terms of how they're being applied in the criminal context, and how fair it might be to the academics to enforce criminal sanctions for not really maybe appreciating or understanding these rules?
So again, I'm not a scientist. I do work in criminal justice and human rights. Probably the last person that the PRC leadership wants to adopt what I do and take it. I wish they would. I'm not their favorite person. So I can't speak directly to how clear the regulations are. But I've spent more time talking to particle physicists and chemical engineers than I ever thought I would. And it seems to me that my understanding is that that universities also vary dramatically in how good of a job they've done at explaining these rules and giving the administrative support to their faculty to make sure they're complying. Because also people, again, these are not just people who are busy and they forgot to check a box, but the more that we can make it so these are clear rules, that you can comply with them, you have the support to comply with them, the more I think also comfort that will give the scientists that they are in a place where they can continue their research without being worried. I'm also not particularly interested in spending a lot of time litigating what happened under the Trump administration. There were so many problems with the way that the whole administration, I think a lot of people at high level spoke about China. I'm really excited that we are now in the Biden administration with people who I think are really interested in looking at how to find a better path forward. So there is, to me, wherever we are, there is room for improvement, and we should all strive to do better. And so I hope that that's the spirit in which we can go forward.
Okay, we're going to get to Q&A here from the attendees very soon, but I have one other topic I'd like to bring out. I know it's not directed specifically at you, Jay, or even Maggie, but one of the things that Maggie touched on was the so-called China-ness of this initiative and its focus on perhaps individuals of Chinese descent. And I remember 2 years ago when Jay and I did one of these programs, there was a lot of concern in the community expressed in one of the programs about what was a perception of racial profiling going on in the context of this initiative. And that can be debated by those, but that's not my question here as much as it is the impact on loyalty, the loyalty of Chinese Americans as raised by you, Maggie, in your reference to the statements of the former U.S. Attorney in Boston, Andrew Lelling. And, you know, Jay, I know that the members of the Department of Justice, including some AUSAs and agents who are of Chinese American descent on the China Initiative, certainly don't feel that they are targeting people because of their Chinese descent. But there is a sense that history is repeating itself, that the 1950s there's been a resurgence of that kind of scrutiny and atmosphere and hostility towards Chinese Americans, particularly during the COVID period here that we're going through, and concerns that when prosecutors go into bail hearings and seek detention of Chinese Americans because they feel like the Chinese Americans are a flight risk and can flee to China even if though they're US citizens, or be called traitors, even though they're naturalized US citizens. There is a concern that the DOJ is getting to a level where they're embracing some of this hysteria. Do you have some thoughts about how the DOJ can address those kind of concerns for the Chinese community? Because we have one professor who's been held in detention since last August in Texas on a case. So there's this growing sense that loyalty is part of this and that people will flee back to the motherland of their country, even though they've moved here, they have kids here, they have US citizens, and that somehow they're getting treated differently than other defendants in this kind of case. So do you have any thoughts or observations or comments you can make about that perception or concern?
I would say that certainly a question of loyalty is not something that should come up in arguments as to detention, unless it's part of the nature of the case. Espionage cases, certainly loyalty is part of the essence of the offense, but I would be very sensitive about raising an argument like that, when the facts and circumstances do not support such an insinuation. A detention decision on a basis of risk of flight is one that is supposed to be decided on objective factors as to whether or not there's a likelihood that the person will comply with the court's orders and show up for cases. I'm familiar with the case of the professor in Texas. I'm not familiar with the arguments that were made at his detention hearing. Dr. Zhang, to whom I referred earlier, was on a specially chartered flight on his way to China. Literally, when he was arrested, he was detained, and certainly there would appear to be objective indicia of a flight risk in that situation. But it should not be the place of prosecutors at a detention hearing to point to the person's ethnicity as a basis for holding somebody pending trial.
Okay.
I would add that the Department of Justice is not monolithic. And I know from my experience that people I've spoken to vary with respect to how sensitive they are to these issues, how they talk about China, even how they pronounce Chinese names. Learning the pinyin to be able to pronounce people's names correctly is a sign of respect. I would recommend to people, if you're interested in these issues, Mara Histendal has written a lot, including a book, The Scientist and the Spy, which is about the Cordenseed case we keep referencing. And that ended up being resolved through a plea. But as it was moving towards trial, the judge said in an order that it limited the ability of the prosecution to refer to the defendant's ethnicity for fear that it could create an unfair trial. And so I do think we're in an atmosphere, unfortunately, right now in the United States, that we need to be extremely sensitive about either calling out directly, perhaps people's loyalty, except if we are in like a treason case where it is directly at issue, but also insinuating that because that is sadly part of where we are. And we're going to need to take affirmative efforts to try to diminish that xenophobia and that just general discrimination against people from AAPI communities.
Okay.
Right. So I thank you, Jay, and Maggie, and also Brian, for that candid and straight discussion, and it's very helpful. And we have very limited time. There was a lot of questions raised during registration. Many more also raised during the YouTube live stream. So I think that would like to enter that the QA session where that Professor Li Qiao will raise the questions that collected during the registration, and then Brian will follow that present the question that collected on the YouTube live stream. Professor Li.
Yeah, thank you all for all the audience for providing your questions. Indeed, we received a lot of questions. Brian has touched some of them. So my first question is, the China initiative has resulted in a few charges of espionage and IP theft. However, most of the cases end up with tax problems or not disclosing properly. So is it fair to interpret that China initiative is about arresting Chinese American scientists who have collaborations with China using the tactics of Al Capone's famous conviction for tax evasion? Or if I rephrase differently, is Department of Justice considering adjusting your guidelines of China initiative to alleviate the unnecessary horror it has caused to the academic community?
I could jump in and defend the DOJ in saying that I want to be clear again that there is criminal behavior that is being punished, and that I think criminal law has a role here, but it should be a backstop. It should not be at the forefront. And again, too, it's not surprising that in addition to looking at perhaps the actual transfer of IP or attempted transfer, that we're looking at cases that haven't gotten that far. And lying to the government under oath is a crime. I mean, look at Al Capone, that was tax. Look at Martha Stewart, right? So this isn't just being used in the China initiative context. So these are real crimes. They're real serious federal crimes that are being prosecuted and they're getting convictions for. So there is a there. And also the PRC government is up to some things which are very worrisome from a national security standpoint. So I think for me, that's why I say calibrate. How do we dial it back so that there's less concerns about overreach, about overemphasis on using criminal law? But I think I'm someone who's a critic of the China initiative, but even I agree that there is some behavior that's going on that definitely deserves to be prosecuted and punished.
Perhaps I can also add that from a criminal prosecutorial standpoint, economic espionage cases, trade secret theft cases involving the theft of sensitive proprietary technology, these are not easy cases to win. You have to show many different elements of proof, including economic damage and loss, and things that are sometimes hard for the prosecution to prove. And in fact, on the flip side, I think you would see, and Jay can correct me if I'm wrong, since he probably knows better than me, that in the academic context, though, I don't think you'll find any criminal prosecution where there was a transfer of any sensitive technology. They are what some of us might euphemistically refer to as got you cases, where the professor has failed to disclose something that he or she maybe should have disclosed on a forum. And but that's where you may have the debate of whether or not you should have criminally prosecuted that professor, or perhaps taken some non-criminal disciplinary actions such as suspending them, strip them of tenure, fire them, something that would be less onerous than a criminal prosecution, because the impact of that kind of thing is not only professional disgrace and loss of jobs, your job, but you are basically forced and left with very limited options once that happens to you. So that in some respects is, and not to be again too flippant about it, sometimes I use the corporate death penalty when I refer to cases where a company gets prosecuted and it basically has to shut down. In the academic world, it's the academic death penalty if you're criminally prosecuted and disgraced in this way and prosecuted, and what are you left to do but perhaps go back to China? So there's debating, there's different views in this, but I again circle back to what Maggie just said. There's some serious bad actors out there. Nobody believes they shouldn't be prosecuted by the DOJ, but query are these academics and researchers and their conduct, given the ambiguity of these rules, should they be subjected to this type of criminal sanction?
Perhaps we can jump into the next question that many audiences are interested in hearing. What is the Biden administration's take on the China initiative? Do you think the China initiative will be revoked at some time?
We don't have Jay here, and even if he was here, he wouldn't be able to say much, both because he's speaking in his official capacity, and we don't even have the new Attorney General in yet. So hopefully we'll get past Senator Cotton soon, and we'll have AG Garland in place, also his deputy to be Elisa Monaco. My hope is that these are people coming in at the highest levels, as well as some of the people who are filling in lower levels, who are committed to trying to bring humility and justice and a more careful sense of understanding how different communities are being affected differently in the criminal justice system. I teach U.S. criminal procedure. I spend a lot of time talking about racism, about how Black and brown people are mistreated in our criminal justice system. That will be a focus, but I also think we're going to see more focus, like this recent meeting with John Carlin with AAPI communities. So I have a lot of hope. And I think the more we can focus on the common ground, on trying to limit the scope of the efforts of the DOJ to these real sort of bad actors, the people we can agree about who are the real threats to national security, and avoid this threat inflating rhetoric that creates a very expansive view of national security, the better off we're going to be, not just in the Department of Justice, but more generally in the US-China relationship. And finally, I do want to point out, I feel kind of bad that we've lost Jay Bratt, but when I looked at the year in review for the China initiative that came out in the fall, and they had several quotes from people working on the China initiative, they were all white men, middle-aged white men, and more importantly, white. It'd be nice to see more women, but I think representation matters. And I also really hope under Biden that we're going to see greater visibility for diversity in the Department of Justice at all levels, because that's an important part of the equation too, not just in the short term, but in the long term.
Let me augment Maggie's points with this observation. For those of you who don't know, and I may have mentioned this in the last webinar, Lisa Monaco used to be at the head of the National Security Division years ago under the Obama administration. So she does have a national security background in coming into the role of being the #2 official in the Department of Justice under AG designate Judge Garland. John Carlin, who Maggie just mentioned, is also a former head of the National Security Division, former boss of Jay. He is not considered to be a lib on this issue. He's a pretty conservative, hawkish guy. I don't think John would have a problem with me saying that. So I wouldn't expect a major sea change or shift in attitude towards certainly the threat posed by, in the eyes of many, who do national security work, in the threat posed by the PRC state to American national security. But that said, I agree with Maggie. We can hope that there'll be a lot less rhetoric, a lot less intransigence, a willingness to listen, particularly to the points made in this webinar and in other sessions you will hear, and that this will be heard at a level not just in the Justice Department, but also at the science level, as pointed out by Maggie, Eric Lander, and the science folks at the Office of Technology Science Policy. They're going to be an important voice in this. I think the Homeland Security folks, the State Department, and indeed congressional committees that, whether they be on intelligence, civil rights, finance, whatever, that fund the government agencies that are creating these conflict of interest questionnaires, that they all get into this and re-examine these issues and the underpinnings of the China initiative with a little more focus on the concerns of the Chinese American scholars and researchers. We didn't talk enough, perhaps, about tonight. We touched on the postdocs and all that who are also impacted by this, but this is going to be an important part of this debate about the United States losing valuable know-how and brain power to other countries, most notably China, who you can debate whether it's state-sponsored theft or whether it's China trying to compete and wanting, like we would want, if a number of our best and brightest were to fled to Germany or to France or to the UK, why wouldn't we want them back? Why wouldn't we want to keep that brain power in the United States if they were going to other foreign countries because those countries offered a higher standard of living, more academic freedom, whatever the reason might be? Why wouldn't you want them back? And so once I think our national security officials realize that this is as much about a competition over the best and the brightest as opposed to state-sponsored theft, and that we need to compete, then I think we're going to make some progress with the Biden administration, hopefully.
We discussed the question whether that Biden administration will make some change in the practice of China initiative. So adding the previous question, can you give up some of your thoughts?
Right, and actually one of my colleagues kept me filled in on the dialogue, so I don't think I missed too much. I don't think there's much I can really add. Hopefully we will have a new Attorney General next week, and this would be something that I know will be of interest. We already have had some internal discussions with the incoming people about the China initiative and again the overall threat picture, but I can't predict. And I think there were references to the Deputy Attorney General. I don't think there would be a decision on something like this until the Deputy Attorney General is also in place, since given her background and also just her role as sort of the chief operating officer of the department, those are the types of things that get discussed often at her level before it gets discussed with the Attorney General.
Well, thank you, all of you. The next question is particularly for Jay in terms of Department of Justice. Is DOJ doing any programs to alleviate racial bias against Chinese American scientists? Or in other sense, how does the China initiative going on without jeopardizing our soft power advantage of attracting the world's best talents to the United States?
To answer the first part of the question, again, it is my hope that people come away believing that I and those with whom I work do not use improper considerations when we make the types of decisions that we have to make. I think it's also well known that in the prior administration, the type of diversity training on issues of implicit bias were not allowed to take place. And there's likely to be a change going forward. And a lot of us will be exposed to ways of thinking about other people that we have not been exposed to before. Again, that being said, we really do try to look at the facts of the case and not the individual or individuals who would be the subject of the prosecution if we go forward. In terms of continuing to attract people, and this is really just me talking as a citizen, not as a DOJ lawyer, it would be my hope that people come to the United States for the reasons that, since most of us are either the children or grandchildren of immigrants, why their families came here in the first place, as a land of opportunity and freedom, and a land where people can express their views freely without fear of repercussion.
Thank you. With that, I'll give the floor to Brian and Zhigang for more questions.
Well, I can certainly fill up our time with more questions. I think maybe it might be good for me just to give, if you want, a brief 30 seconds or whatever to each of the panelists on any parting observations or comments or points they want to leave with the attendees. And then if we have time, I'll throw another question out, but I just thought I'd give each of the panelists some opportunity to leave the audience with some message that you want to leave regarding your perspective on the China Initiative and its future course.
So I don't know how much I can really add to what I just said in response to the prior question. I hope that I've been able to paint a picture of the overall threat that the United States faces from a number of different sources, how we seek to use our very limited tool, the criminal justice system, to address those threats, not only as they come from China, but from other adversaries. And to again impress that in addressing these threats, particularly with respect to China, that we are doing so neutrally, and that we are doing so to achieve the greater goal of enhancing the national security, and not to punish people based on their country of origin or ethnicity.
And I would just add how delighted I am that we're having this conversation, that we have participation from the government, that these conversations, obviously we've already gone 2 hours, that we need to have a lot more of them. And then finally, that we've been speaking about the executive branch. Congress has come up a few times in passing. I want to emphasize with all these people on the line who have phones and email that we should encourage Congress to pass legislation that's supporting our indigenous innovation, that's supporting STEM studies and supporting language learning. We need more people who are Chinese speakers, not just because they learned it at home. And that also one push that's being made by some of the advocacy groups, Asian Americans Advancing Justice, APA Justice, the Brennan Center, is to try to have a hearing in Congress to get more of the voices of the AAPI and even PRC passport holding community in front of Congress, because there's been a number of hearings and events focused on the national security side, but I don't think there's been enough opportunities for members of Congress to hear the voices of those from affected communities. So we need to push for that hearing to occur as well.
And one thing I might add to that is that, and I mentioned this in the last webinar, it's going to be very important. I think this sea change I referred to earlier with Professor Chen's case out of MIT is galvanizing non-Asian groups, faculty who are non-Chinese American, to get behind this focus on re-examining the China Initiative, at least in terms of how it's perceived by many, and most notably the administrations of the universities and the institutions that you work at. There are some in the criminal defense bar who believe that the universities could have done a better job at interfacing with the agencies and informing the academics about the perils of the China Initiative or how to fill out these forms. No one is going to engage in the blame game, but this is one where university administrations are now beginning to step up and back up faculty. We'd like to see more of that. And we'd also like to see whether it's the boards of trustees or the administration of these major institutions in this country, who encouraged many of you to do cross-border China collaborations and get involved with Thousand Talent programs, to stand up and back up your professors. So I just throw again my editorial comment, which I of course am want to do in these things, so forgive me for that. But I want to thank Jay and Maggie for joining us tonight. Jay, for you coming out here and braving the storm. I appreciate it. And Maggie, you waking up early on a Sunday morning in Taipei or Taiwan and working with us. So I want to thank everybody for participating and giving us the opportunity to speak with you tonight.
I try to relay that thanks to Jay and Maggie and to join us. This is a great conversation and debate and dialogue between the government and the human rights lawyers, academia, about this China initiative. What I observed in the last 2 hours, what we agree is that economic and technology espionage should be punished, no doubt. At the same time, that international collaborations and academic freedom and exchange is the foundation about the U.S. science leadership. And the talent is also critical for maintaining U.S. leadership in technology, including those talents from China. And I also would like to remind everybody here that tonight is probably a dialogue between scientists directly with the government. And Jay, I really appreciate that. And Maggie, thank you for joining us. I think university play a critical role and in this process. And for example, in the last a few months in our university at Princeton, and the administration provide extensive training program and revise their disclosure forms. And many of us had several rounds of conversation with the university. They are learning too. I think that in next time we should engage not only academia, but also administrations of universities to this dialogue. And hopefully that we can come together and to do something, punish the real wrongdoing. And for those really that involved in misconduct, we should develop something like Maggie said, is that a non-criminal discipline or punishment. And then we should also avoid that the biases and discrimination on campus so that we can still make America truly great, attracting foreign talents, keep foreign talents, and keep our technology leadership, and then really make that our technology a superiority in the future. Thank you, everyone, and for joining us. It's really late, and a lot of people online. I thank you for the participation as well. Thank you. Bye-bye.